and then we'll just take it from there. So again, thanks, Vicki, for doing this. There was a wealth of folks that signed up for this, so I know that this is a pretty popular conversation piece. So thank you all for joining.
All right, hello everybody. I hope everybody can see my screen. If I can't, put it in the chat or something, so we can just keep moving on. So if there are so many people on, I just want to, I am not an attorney, okay? So I am coming from this from resources, lived experience with other families, you know, doing my due diligence with attorneys across the state as well. So tonight on guardianship. So guardianship is the legal process when a person can no longer make or communicate safe or sound decisions about themselves or their property, which is typically in a conservatorship. Establishing guardianship may result in considerable loss of a right for an individual. The appointment of a guardian is done by a court order after a hearing. The hearing is to determine whether the individual lacks the ability to make responsible decisions concerning legal affairs, possibly medical treatments, financial affairs, housing, and are also concerning their safety or health. Courts will always look at the least restrictive for that individual. And so we're going to go through this and talk about guardianships, but we're also going to talk about the alternatives for that. So what is the legislative intent behind guardianship? So it is the intent of the legislator to protect the liberty and autonomy of all people of the state and to enable them to exercise their rights under the law to the maximum extent consistent with the capacity of each person. So our legislator recognizes that people with incapacities, though, also have unique abilities and needs that some people with incapacities cannot exercise their rights or provide their basic needs without the help of a guardian. And as we go through tonight, you will see the alternatives. They may be able to have help without a guardian. It may be some other form of help. However, their liberty and autonomy should always be restricted through the guardianship process only to the minimum extent. So some of this is repeat, but the reason I repeat it is because I think those are important words and sentences that we're talking about here for persons with disabilities. And so I kind of repeat them now and then to just remind people of what we're looking at. Really, my screen is frozen. Okay, I'm going to try to stop here and go again because it's frozen. I'll try one more time here.
Text.
Okay. Sorry about that. Okay. So types of guardians. Okay, so there's a general guardian. That's a guardian or an agency, and we'll talk a little bit about this. Agencies coming up that has general care and control over awards, and we'll talk about the definition of what that wards is, or the person or the estate responsible for both the well-being and financial interests of the ward. Okay. There's a limited guardian. Limited guardianship is one that is responsible and makes decisions for a ward in areas that the ward may not be capable of making decisions in. One of a lot that you see is financial. There's also a term called temporary guardian. So a temporary guardian is a guardian where one is appointed as needs immediate action and is only in place for 90 days and then ends, or the process of a general or a limited guardian then can take place. So to discuss just a little bit more about these different types. The temporary guardianship, I start off with that. So that's one appointed, like we talked, in emergency situations. So this may come about, the ones, I guess, that I can say that I've helped with or have helped with resources and support with. Happened when a person over the age of 18 with a disability that was defined felt like there wasn't any need for guardianship maybe at 18. Maybe they weren't understanding what was happening. Maybe the person with the disability itself had contested its guardian, didn't want to have a guardianship, but then something happened. Maybe something medical, it could be something legal that happened. And so sometimes you need to get a temporary guardianship, which a judge will order. And again, like I said, then you have 90 days to complete the rest of that, whether it's into a general guardianship or a corporate guardianship, which we'll talk about, just to finish that process. Okay. Partial guardianships can happen. Again, those are just for limited. So maybe someone can, with member of your family or who's over 18, you feel they can make their own decisions in certain areas, but are really worried about maybe them signing a contract with something, you know, buying a car, signing a contract, anything to do with financials. Typically, if it's probably just one, you want to look at one of the alternatives that we're going to talk about especially financial, but sometimes people just feel in a couple areas that's all they need. So you can ask for a partial guardianship. And of course, then a full guardian is really what it means. You're making those decisions for someone. You're in control of that. Okay, so now we're going to talk about some of those definitions. Okay, so there is a lot of terms and definitions when you go through guardianship. When you're going through guardianship, you can actually, I mean, it is not against the law to do your, as parents or caregivers, to do your own guardianship. It's probably not highly recommended if you don't have any legal background. There's a lot of things that need to get filed. There's some court, you know, fees that you're going to have to make sure that you're getting those correctly done without an attorney. I would say most of the families that I've worked with have gone through an attorney, but there is a self-help, and that website will be on here, and it tells you the process to go through for guardianship if you choose to do on your own. So the petitioner is the person who petitions the court for guardianship. So when I sought guardianship over my son, I was the petitioner. The respondent is a person who replies to the petitioner. And of course, the ward is the person for whom the court appoints a guardian. Then there is documents itself. The petition is the court to appoint a guardian. The guardian is a person the court appoints to protect the rights and manage the rights of the incapacitated person. Then there is a guardian ad litem, which is probably a term that if you've done any research or work or thinking about guardians, you see this term a lot. The guardian ad litem is an attorney who represents the best interests of the proposed ward. He or she visits the proposed ward, evaluates all of the available information on the case. Then he or she then files a report and recommendations to the court. And it should say it doesn't have to be an attorney. There are some guardian ad litems that are not attorneys. A guardian ad litem makes recommendations based on what he or she feels in the best interest of the proposed ward. Then also through this process, you have a visitor. A visitor is a person appointed by the North Dakota District Court to interview the proposed guardian and the proposed ward. The visitor gives a written report to the court, which includes, again, recommendations on powers to be granted to the proposed guardian. The visitor is a person in a nursing or social work with no special interest in the guardianship proceedings. Most of the ones that I've helped end up typically being a social worker. Then there's another term. This happens towards at the end of a guardianship when it has gone through the court. You get letters of guardianship. These are the documents that the court states what guardian powers are and whether they are specific to limitations. The guardian presents the letters when needed to show what powers they have, such as dealing with financial issues or medical providers. So on this, you know, there are certain things that you may have to show that you are the guardian for, maybe Social Security. maybe some banking accounts, possibly some medical, or some life insurance, any of those types of agreements. You might have to prove that you are the guardian. And so you would be able to present those letters. You also will hear the term incapacitated person. An incapacitated person means any adult person who is impaired by reason of mental illness, mental deficiency, physical illness or disability, or a chemical dependence to the extent that the person lacks capacity to make or communicate responsible decisions concerning that person's matters of residence, education, medical, and other areas. It's not the kindest term, but it is a term that you'll hear. And also informed consent means that a person agreement to a proposed course of conduct. When you go through the guardianship process, you also have a physician's report. So typically from a primary care, a report that is required, not in all states, but in North Dakota, it is in relationship to guardianship proceedings, which substantiates the need for a substitute decision maker. A lot of times that's determined to determine a disability. Their report will reflect that. Like for my son who has autism with ID, that's what that report said. It stated how he was diagnosed, which tools were used for autism and intellectual disability. Interested persons, these are other terms you will hear. These are individuals who, according to the state statute, have a right to notice regarding a guardianship's cause of action. This may include parents, siblings, spouses, and a residential provider. In my case, my interested persons were my son's grandparents, also his trustor of his special needs trust as well was an interested person. For interested persons, then they get notification of the guardianship papers as well. And then we're going to talk a little bit too about corporate guardianship. So a corporate guardian is a corporation that is named as a guardian for an individual and that may receive compensation in its role as guardian with a court approval. Okay. So that's a lot of words, and you're going to get this PowerPoint, but those are words that you're going to hear throughout the guardianship process. So I just mentioned a little bit about corporate guardianship. So why would someone seek a corporate guardianship? So there are plenty of different reasons of why that may happen. First of all, if you felt as a parent that you weren't capable of being a guardian, maybe the person you want to seek guardianship over really is contesting that they don't want you as a parent or someone else person as a guardian, but the court still feels that there needs to be a guardianship set up. You can go through corporate guardianships. I've had a few where the parents were, let's say, up in age and were worried about not setting up or didn't have any other family members that would be like the next in line for guardian or a co-guardian. And so they chose to go with a corporate guardianship to begin with so that everything was taken care of. So there are different reasons. And in North Dakota, the biggest one we have, of course, is Catholic Charities of North Dakota. But we also have Guardian Protective Services is located in Bismarck. There's Guardian Angels out of Jamestown. But by far, Catholic Charities does the most in corporate guardianships. Okay. So any questions so far? And if we get to a question that is completely like out of my realm and really needs an attorney to answer it, I can seek out that information and then get it back to you as well. Okay, so let's talk about when we're thinking about guardianship. what are questions that we should probably ask ourselves, or the alternatives to guardianship? So I think one of the first things you want to look at is, what do you want your child's future to look like? So, have discussions, with people who work with your child, have discussions with your family. As your child gets older and closer to youth age, maybe, you have discussions with them, before this process begins. Really think about what you want your child's future to look like. And remember that guardianship is not, it's not something that is, would benefit everyone. There are definitely alternatives that we'll talk about. So, I mean, you should take this really seriously, because like the intent of it is, you're taking control of someone and they're losing their rights of control. So it is something that you really want to think about. And in some cases, the guardianship is a must. In my case, I thought about it, but there was really, to me, there were the alternatives to guardianship didn't fit my son's life. So we went with that, but you definitely need to think about those things. So another question you want to ask is, have you spoken to your child about guardianship or alternatives? Okay. In some cases that might not work. In my son's, he has ID. He wouldn't have any idea what I was talking to him about, but that's not the case for everybody. So when we're thinking of guardianship here, and what I'm talking about tonight is adult guardianship. This is not guardianship over a child or a minor. That's a whole different process. And to remember that, so I, believe it or not, I get a lot of calls where people call me and they say, well, he's going to turn 18 soon. And, I want to think about guardianship, and I got to get guardianship right before he turns 18, because if he turns 18, he gets to make his own decisions, right? Well, if you got guardianship right before they turned 18, as soon as they turn 18 again, you have to go through adult guardianship. So just know that this is something you want to think about ahead of time. And yes, when they turn 18, they're as an adult, but there are certain things that, protect that as well. Okay. Like if he's in a car accident and something medically happened, I have a lot of people ask that. Well, you're the next of kin. So there are, decisions then, but in the long run, those decisions you want to think about, getting that guardianship established around the age of 18, but the door never closes on that. Okay. And then we want to talk, which we're going to talk about. You want to know your options. Seek out all the options that you feel there are for alternatives to guardianship and weigh those out. You also want to think about the cost, because hiring an attorney that costs. We have 2 programs in the state that can help with costs. They're very limited, and we will discuss those. But there is a cost to guardianship in North Dakota, from my experience and speaking to attorneys across the state. It can vary anywhere from around $1,500, up to about $4,000. And then you think if you have to do emergency guardianship, you have to pay through that, and then you have to pay again. Okay, so some of those can go up extremely high. Okay, so we want to think about that there is a cost for guardianship. So if you think about it early and you think that this is something you might need to do, you can start saving early. And we're not talking about it tonight, but I'm a big proponent of ABLE accounts for persons with disabilities. And if you save early, you can save money in an ABLE account, which maybe we'll do that another night and we can talk about that. But you can use the money in an ABLE account to pay for guardianship, and which is what I did for my son. We saved up money so that way I knew we had money when it came around time to do guardianship. Okay, but there is a cost. You want to think about, what are the strengths and weaknesses of my child, and how do they manage life situations? Okay. And that's going to, again, vary for everyone. Sometimes people will ask me, well, he has this certain type of disability, so of course there needs to be a guardianship with that. Well, they may have a certain type of disability, but everybody is completely different. And so they may be able to manage things on their own, certain things. And so again, weigh out the strengths and the weaknesses, and then talk about your child. If you're able to talk to them about that and they're able to understand those processes, you know, ask them what they think their strengths and weaknesses are. And then what if guardianship is sought, but my child doesn't want a guardian? Every child that is turning 18 and going through a guardianship process has the right to contest their own guardianship. If they are contesting it, a judge will hear their why they are contesting it, any evidence from that. And so different decisions can be made on that. And the judge will put down his decision for that, or his recommendation for what that contesting is for. Is it valid? Is there enough information to support that? And sometimes that is where corporate guardianships come into play. And I've seen those, and I've been through some court hearings where that has happened. Okay. So we talked a lot about guardianship and mentioned a lot of the words about alternatives. So this little triangle will tell you what's the most restrictive and the least restrictive when we're thinking about supporting a person, making their decisions for them, or having somebody else make their decisions for them, or having help making their decisions for them in whatever area that they might need. So you can see that guardianship is at the very top. Some of these we don't always hear or see about in North Dakota, but guardianship would be one that you're going to hear a lot of. Representative payee is something typically that you hear when a person is getting Social Security, whether it's SSI or SSDI. They have a representative payee. Some folks in group homes, that's their representative payee, would be that group home. That's kind of, you know, in the middle right there with power of attorney, because a lot of times power of attorney, we're talking about financial means that they need some support in. So those two are kind of lumped together. And then we're going to see down at the bottom there, the least restrictive is supported decision making. And we're going to talk a little bit about that as well. That's probably one of the, as far as I can see, that's the one that is the newest out there. That isn't an option. So it's fairly new. It's been around for a little while, but it's fairly new. So they're just listing again. So as I talked about, like, what's a representative payee? So a representative payee is a person, or it can be the organization. Like I said, in North Dakota, you'll see group homes have that a lot, that we appoint a payee to receive the Social Security benefits, SSI benefits, who cannot manage those direct benefits that go for them. So a representative payee must spend the disability benefits appropriately for the disabled person's need. They must properly account for the money that is spent. They must do all the reporting that goes along when you get SSI or SSDI, especially with SSI, there's a lot more rules. And you're going to find that persons with disabilities, when they turn 18, that's another program that they're going to apply for to see if they can collect those benefits. SSI is based on the disability and the low income and low resources. So it's based off of need. SSDI would be based off of more of their work history. But there's still a lot of reporting that needs to be done with this when you're being a rep payee for a person. Individual representative payees cannot collect a fee for services provided by the beneficiary. So if you were a rep payee, and that's the least restrictive you have done when we're thinking about making decisions for someone, you cannot pay yourself to be that rep payee. Okay.
And so another one is power of attorney. And I get a lot of questions asked on this. And again, I'm not an attorney, but I put this up to just kind of show you the difference of what a difference between a power of attorney and a guardianship would be. So in a power of attorney, you can name the agent to handle the affairs before anything happens. Okay, so you don't have to have a reason at 18 to access a power of attorney. And the guardianship can only be attained after someone has become incapacitated. Okay, so you think about that as a power of attorney, they don't have to be incapacitated, but in a guardianship, they have to be incapacitated to some extent. Okay. Power of attorney is a legal form, but it's not a court form. And a guardianship is also legal, but it is a court form. A power of attorney costs less, takes less time. A guardianship will usually cost more, it takes a little bit longer to set up. Not all institutions may honor a power of attorney. We have found out that in North Dakota in the last couple of years, was brought up in our last legislative session. And then in a guardianship, it's set up by a court system, so they will honor what the court has declared. And a power of attorney allows for more ability to make some choices depending on the type of document. And of course, a guardianship, which again was at the top of that triangle, is more restrictive. So it's going to hold those less choices for a person. So any questions on those two things? So here's the one we're going to talk about, which is the least restrictive. It's called supported decision making. So before we get into exactly all what it is, supported decision making has been around a lot longer, but mostly it started over in Sweden actually, and then Canada adopted a lot. And for the United States, probably one of the first cases, I want to say, and I forgot to write it down, but I think it's around 2015, started with a 29-year-old woman with Down syndrome who was under guardianship. And she felt like she could make her decisions on her own with some friends helping her make those decisions. And so she had an attorney and they fought and they had to fight for this and went through courts. But that's kind of how supported decision-making actually started in the United States. Okay, so what is it? So supported decision-making is a tool where a person with a disability can be empowered and supported in the process of making their own decisions to whatever extent possible. It's an alternative to guardianship. So it's really an acknowledgement of that individual that when they enter into the supported decision-making agreement, which we'll talk about, they don't have to surrender their right to make decisions, okay? So that could be for all kinds of folks, you know, for all kinds of people, young people that might be seeking guardianship for. So think about those words where they don't have to surrender their rights to make decisions, because those are important words. So in North Dakota, on March 19th, 2019, Governor Burgum signed House Bill 1378, and supported decision-making was recognized by law. North Dakota became the 7th state to sign such a bill. And the last I looked, I think there's 25 states that have signed a similar bill. And so a big thank you in North Dakota for all those that supported that bill, along with North Dakota Council for Persons with Disabilities and Protection and Advocacy, along with all the advocates, along with people who are on this call tonight. That was a pretty important bill, a pretty important piece of legislation, especially for persons with disabilities. If you want to read about it, that is the website that you can find the bill on. But when you enter into supported decision-making, it ends up being a written agreement that formalizes supported decision-making, and it is recognized as so. So it is recognized as an alternative to guardianship. So this is really a complete paradigm shift from where we used to be. Okay, guardianship really, you know, anybody who they felt could not make decisions or didn't always make the wisest decisions, guardianship was really the only way to go. That's how people thought. So this is a paradigm shift. So we think differently now. And so it's really a huge expression of self-determination when we think about supported decision-making. So under supported decision-making, changes can be made to the agreement at any time, which is different than guardianship. You'd have to go back to court with that. And the court system and the law must, after this bill was signed, must recognize this as an alternative to guardianship. And also the American Bar Association has long been committed to advocating for these least restrictive alternatives to guardianship. Other national agencies has well, the National Down Syndrome Council, Family Voices National, they were all big supporters of supported decision-making. So what does it really look like, and what are the roles that we have? So the center of supported decision-making is a decision maker, okay? So that is the person who you're thinking about that you may have thought that we're deciding, do I go guardianship? Do I go rep payee? Do I go power of attorney? Or should I be also looking at supported decision-making for that person? Because they are the decision-making. The decision maker chooses people whom he or she would like to have help make decisions. The decision maker chooses what kind of decisions and what kind of help they would like support in. So we may be talking about this person with a disability. They are the decision maker, okay? Which is why it's underlined a lot in this little slide here. The decision maker chooses what want to help them make decisions. They choose those people, and they are called supporters. So supporters can be anyone they choose. It can be family members, providers, or anyone, as long as they agree to serve in that role. So I'm currently a supporter for 2 young adults in the state of North Dakota. I've gained a lot of experience working with them and being part of that process of supported decision-making. It's probably taught me more than any words on this PowerPoint are going to teach you. It's interesting how they can come and how they look to you for advice, but expressing their own opinion, expressing their determination has been really enlightening for me. So there's a lot to learn from that. And for the 2 folks that I'm helping, this absolutely was the best decision that they made, was going into supported decision-making. The supported decision-making agreement is a written plan. It's developed, again, by the decision maker and her or his team that gives information about who the supporters will be, what kind of decisions will be supported, and what kind of support is requested. Okay. So some examples that we have, these are 3 that I actually that I support with, but it can be in all kinds of areas when we think of supported decision making. So one that I help is learning to help manage money. So the decision maker can get advice from the supporter, like in this case was me, on how to set up money management apps on their phone. Okay. Once they get that app set up on their phone, they seem pretty easy about how they can manage money there, but they needed help getting that on their phone. So that's supporting them. There are plenty of other things that when you think about money that a supporter would be able to help with. Health. When we think about that, we think that a supporter to come to medical appointments to help, or it should say medical appointments, to help understand procedures. So I've gone to some medical appointments with my 2 decision makers, just to listen. Sometimes I take note. They ask me to take notes so that when we leave, I can give them notes or I can send them to them in a file, because not everything that they want is going to come out of my chart. So that's another support that you can do. A lot of times in health too, when they're using big words, you know, sometimes I look at them and they're like, I said, did you understand that? And they go, no. So then, you know, I'm helping them request from the physician to go over that again. Sometimes it's in housing, supporting to help explain the language on a lease, or I've helped out where they're applying for housing. And they need some support in that area of filling out the application. But again, they're the ones making the decisions. They're the ones that have decided that's where I want to live, not me telling them that's where you live. They make those decisions. So there are some examples, and I'm going to try to share some here. What supported decision-making agreement might look like. I think this is, when I do some trainings, this is the one where people ask me them. They do and don't ask me the most questions, because it might be the hardest for them to kind of grasp. But when I go back to the PowerPoint, it'll give you a website to go to this place. So these are put out by Protection and Advocacy. And I think they got into a word, but give you examples of templates they can use for supported decision making. So, I mean, basically go through your personal information. And then you can see down here, it's going to say supporter's name. So who's ever supporting them, it'll go in this agreement. There's things that the supporter is going to help them with, and it's defined, like collecting records, documents, organizing their records and documents, identifying choices. Those can change, because those would change on what the decision maker wants wants the supporter to help them with. So some of these can change, but like here on number 6, explaining how I'm using decision-making process as allowed under the North Dakota Century Code, chapter 31 through 36. So this is actually the code to create supported decision-making agreements. These will come out to you as well in part of the when she sends out the materials along with the PowerPoint. So you know, there's also a spot in here if you want to terminate it. So maybe the decision maker doesn't want you as a supporter anymore. They have the right to terminate you as a supporter, and that'll be spelled out in the agreement. And here it goes to, it talks about, again, what I talked about of where you want that support help in, you know, whether it's health, mental health, money management, managing home, managing property, getting education, legal affairs. There's also typically a lot of paragraphs where you can go on to explain it in more details. I think this is a very important part as well, is areas I do not want my supporter to help me with. Okay. Basically, signature of the agreement. You can get this notarized, or you can have it witnessed by 2 different people, qualified adult witnesses. Okay. But those are the required. Most that I've seen have gone and gotten a notary to sign these. Okay. But it gives you the options for 2 witnesses. That's kind of a template or an example of what supported decision agreement might look like. Okay, let's see.
Hey, Vicky, I have a question. It's Roxanne.
Yep.
Have you ever had a situation where folks have had maybe a limit to guardianship and then had a supported decision-making agreement for other areas? Would that be a possibility?
It can be a possibility. Actually, it's very weird that you just asked me that, Roxanne. So I just did a transition training in Fargo, and somebody asked me that question. So I actually called an attorney and sought out some information on that. And there's nothing preventing a limited guardianship and a supported decision making. The reason the attorney told me was because supported decision making is only recognized by the court. It is not a legal court document, if that makes sense.
Yep.
Okay. I also had a situation where someone, you know, just when you're thinking about things, tried out a supported decision-making agreement, and of course then found out it didn't work. You know, so those are things, you know, it was hard when it was found out that it didn't work. But unfortunately that person got into legal trouble and a supporter wasn't there to help them. And so they had to go through an emergency guardianship. And the reason I'm speaking of that is, you know, when we're thinking about supported decision-making, when you're choosing your supporters, you know, just make sure you're not choosing random people that really don't know you, don't know your wants and needs, don't have a lot of background in that area. You know, this person just randomly chose a few people and it didn't work out, you know. So I mean, it's things to think about. So sometimes when a young person will call me, a young adult who wants a supported decision making past the age of 18, has nothing else in place. I mean, that's one thing I try to do is said, well, set it up like an interview. You know, ask people who your questions are. And so I think that that works out well.
I'm going to ask you one more question.
Okay.
Sorry. Could you talk about a little bit about education and decision making and what happens? Because most of everybody in our room will still be in school at 18. So would you be willing to talk about what happens there a little bit, Vicki? Or I don't know if you're getting to something like that, but.
I'm not, but I can. But I'll talk from it probably from my own experience and something that legally has to happen there. I've heard different things from districts on how it's happened, but so when your child is on an IEP at school, when they turn 18, of course, things change. You know, a lot of things change at 18. And so they get to make their own decisions. So they could choose not to have you be a part of the IEP at age 18. So it's something that you have to discuss with your child, but it's also something that the school has to discuss with you during a transition IEP meeting. So like some folks I know in some districts had to sign a temporary power of attorney type of paper. I haven't seen it. I can't tell you what it is, but like in my case for my son with an intellectual disability and autism, I was in a meeting. My son was there. He's mostly nonverbal. He would not understand why we were there. But the case manager asked him if he wanted his mom, and then she said my name and said to continue to be part of his IEP team. And he had his little assistive technology device, and he said, he didn't say yes, the device said yes, and he shook his head. And so it was signed off that I was a part of that. But it is a discussion that you have, that if you're on an IEP, the IEP team has to discuss this. It has to happen in a transition meeting. Is that helpful or not helpful?
Mhm.
Well, yeah, I think it was helpful. It's very accurate. Yes.
Yeah, it's hard sometimes because I'll tell you from my own experience, just coming from lived experience, I thought, well, this is just kind of weird, right? Everybody has known my son through the school years. They know he can't make those decisions. His ID level is at that point. And one of the questions I asked, I said, well, what if he doesn't push, yes on his iPad or shake his head yes? I mean, what if he actually shook it no? And his case manager at the time told me, I don't know, we've never had that happen.
We're
And
all
I said,
agreeing to that possibility.
right, like they didn't have a good answer for me. But it was a question I asked. So what if he actually said no? Unfortunately for my case, my son doesn't like the word no, so I'm pretty sure he wouldn't have said it. But there are the other, in other cases, it's going to be where they can actually understand the process. My son attended the IEP meetings like they're supposed to, from 14 on, most certainly should attend the IEP meetings. I had him there, but most certainly it took a lot to get him engaged. Okay. So we have to think about that when, our children are getting close to the age of 18, in the education, but in everything, so it's really good to start thinking about these things early, I believe, just to at least have all the information you can, because that's the only way you can make informed decisions.
We have
And
another.
I had really, yep.
Sorry.
Well, I'm kind of in that same vein. I know with like medical records, at some point, you have to have your teenagers sign off, and I don't know what age that is, but I feel like it's coming up soon.
Yeah.
Can you
Oh, is
hear
that
us?
18?
It
Okay.
is. I have no.
I don't know, Vicky, if you could hear. We were
It was
wondering
some-
what age you have to have your teenagers sign off for medical records.
That's 18.
to have access to them, or
No, for you to have access to them.
That's 18 as well. Okay.
18, as far as I know. I'm not, that might be more legal than I can answer, but I'm assuming it's 18
Actually, Vicky,
or
I had,
14, right? 16
Yeah,
something. I know.
it was 14 for me when
Yeah.
when the kids turned 14, they had to sign a document that said I could see their medical records.
It was kind of interesting because we go to CHI and Sanford. So CHI, I lost access to his my chart. We just signed him up for a different one, and Sanford is still okay with him being under 18. So it's kind of interesting in Bismarck, at least.
Thanks.
Well,
Vicky.
that's kind of interesting too, because then, like I said, I'm not an attorney, but it would be interesting to know if they can do it differently, right? How can one hospital say it's okay and another one say it's not, even though we're both seeking out medical records? I don't know. I mean, it's something to think about, I guess. And, I'll be honest, I can't answer that question. Once I said 18, I remember I talked to somebody and theirs was like 16, but if our director's saying 14, that might be something that we need a little bit more information on, that I could probably seek out. How about any other questions?
Vicky, I'm sorry, I'm like taking up all the air, but one of the things that I felt like changed in the last legislative session is that you can now start seeking guardianship for an adult 6 months prior to age 18. I don't know if 6 months is right, but you can start prior to their 18th birthday.
Of the process?
Yeah,
Yeah,
I'm doing it right now. James will
Yeah,
turn 18.
That's kind of, so when
Yeah.
that's been in place though you can start the process.
No, they can actually appear in court prior.
Yep.
Prior to their
Yes.
18th birthday and have it dated on their birthday.
Okay,
Yes.
so you're talking about the whole guardianship.
Yep.
Right. A full
Yes,
guardianship.
that has changed in this legislation. I thought you meant just starting a process of this.
No,
Yes, that did change. And I don't, I wasn't able to hear exactly all of went on when that came up in legislation. I mean, I saw it afterwards. I knew it was coming out. But I'm sure are some pretty good reasons of why that change came about, let alone COVID. Okay, anybody else?
So if we have, we want to do the decision making one.
Supported
you-
decision making? Mhm.
Yeah, the supported one. So do you give it to like all the doctor's offices, or like is it just basically an agreement that you and like, for example, like my son, he's going to be 17 here in December. Like if he wanted me to be the decision maker, for example, for him, do I send it to a whole bunch of places, or is that just kind of between us? You know what I mean?
Well, it's for him to present. So if he was going to a physician, the physician might question of why you're still in there. They may or may not. I mean, depends on who you go to, but it should be presented to them that, you're there just to support him in his decisions. But again, that's his decision. It would be his decision whether he wanted you in like a case, if he wanted you to help him with health or medical appointments. It's his decision to say, hey, this is what I want you to do, Mom. And that would be written into your agreement. And then you could present it to the doctor.
Does it go in like the church though? Like we scan it into the church or scan it into things like so that they can see that somewhere?
Yeah, so the only one I've helped in the health is, and they presented it on paper. Okay, so they used the template that I shown and they presented it to their primary care physician, and it was in, it was scanned and it was in their file. It wasn't up in my chart or anything. I'm not saying it couldn't be though.
Okay, thank you.
Yeah. Because when we think about supported decision making, again, it's the least restrictive. So if that person is doing that, let's just say you forgot to present it, you still have that agreement. It's still binding. But kind of like healthcare directives, sometimes they don't ask if it's a family member. Since you're his mother, they might have been seeing you come in before, they might not even question it. But if this is what your son is choosing to do, a supported decision making, I would hope that he would want to present that to him, so that they would know he's making his own decisions and you're only there in a supporting role. Does that kind of make sense?
Yep, thank you.
Okay. How about anybody else? Okay. Oops. It's stuck again. There we go. So let's kind of look at the time process of what you have to think about when you're going through a guardianship. Okay. So as I misunderstood Roxanne's question before, you can definitely think about this process early, and you should start the process early. Because it does take time. And it even takes time if you're seeking out an attorney. It's great if you have a family attorney that and they're going to do this, that's great. But otherwise, you may have to shop around. You may have to ask of who might do guardianships. A lot of who are practicing family law, of course, are going to do guardianships, others as well. But, you might want to comparison shop if you don't have an attorney in mind. So that's one of the things. Like I said, you retain an attorney unless you're brave enough to do this on your own.
You collect and process the information on the proposed petitioner and ward. So we kind of went through those definitions. And then there's a guardian ad litem appointed, a visitor, and an expert examiner. Guardian ad litems, usually the attorney has a list of who they can be, but I've also worked with ones that somebody else knew who a guardian ad litem was, so they use that person instead. Like I've said, a visitor is typically a social worker that an attorney would know, and then your expert examiner would probably be your physician, your primary care physician. So they file the petition with all the statements. There's a lot of paperwork that they have to file with this, and there are some filing fees associated with that. But all this, just even that first portion just takes a really long part of time. Because you think about trying to get the guardian ad litem, and when that guardian ad litem comes to your home, the ward must be there. So for, you know, they have to be present. The guardian ad litem will probably ask them questions. Again, this is where I came to the point of really, my son is not going to answer you. My guardian ad litem was somebody that I knew, who knew my family as well, but you know, he still asked him questions and wanted to know what Aaron's reaction was. So I know I have some parents that'll say, well, that's just like, it didn't make sense to me, Vicki. And I'm like, but when you think about it, it does. You know, they're going to be asking you questions as well. The same happened with the visitor as well, the social worker. But I found it very interesting. And if you're doing this while your child is still 18 and in school and on an IEP, the visitor typically wants to have a copy of the IEP as well. So all this filing of paper happens, and then they prepare the notice of hearing. Some people ask me, well, the hearing date, my child's going to turn 18 before the hearing date. Yep, that happens all the time. It's typically around the age of 18 when you start this process early, but yeah, that happens. Again, it's not a worry. They serve the notice of the hearing and the statement rights, and then they sign the orders to appoint. So all these words that I'm saying, I'm going to give you the website and you can go on and see what actually they all pertain, but they're basically orders. They're the information that you give, that the guardian ad litem gives the visitor and the physician. So they file all the proof of the affidavits, and then I think it's on my next slide, the guardianship. Yep. You have to complete a guardianship training and present the certificate to your attorney, or so the courts can have. So this guardianship training, you go online and you take this training. You're not graded on it, but it talks about the processes. It's a little quiz, and then it asks you, you know, if what your answers may be, multiple choice, just to give you an idea of how that process works. But it is required in the state of North Dakota. And then you just attend the hearing. Typical non-contested hearings do not take very long. Contested hearings could take a little bit longer. Okay. So here we have, there's the website right there. And also the guardianship training, that website. So those two pieces are something you have to do. And so after guardianship is established, there's also paperwork that you must do. There's a beginning inventory. There's also an annual report that you must do once a year. And in the state of North Dakota, we have a 5-year review of guardianship. Okay. For the 5-year review, you typically do not need an attorney with you. That's just reviewing it. When you get your letters of guardianship, you'll read them and you'll see the word expire in 5 years. That can throw people off for some other programs, which we don't have time to get into tonight, but just know that that expiration means that's when that 5-year review of guardianship comes up. I have had some people who weren't notified about their 5-year guardianship, so you keep that date in mind. You know, you might want to be calling the clerk of courts, just to make sure of that. Then we're going to talk briefly about 2 of the funding sources that you may have to help with guardianship. One is just the North Dakota Guardianship Establishment Program. So this is a state-funded program. You have to have limited income and resources. So the ward has to have a limit of 100% of federal poverty level. And this one, the consumer or the person who you're seeking guardianship over cannot be eligible for DD program management. Okay. But then I have highlighted there, we're going to talk about new. This just happened in the last legislative session.
Vicky,
Okay.
Vicky,
Yeah.
it's Deneen.
Yeah.
There is a question in the chat.
Okay.
And it asks, does the training to become a guardian cost anything?
No, to take the test, you mean?
Yes.
Yes? No, that's just part of the process. There's no fee involved in that. The fee comes with your attorney. And a lot of times that includes the guardian ad litem, the visitor. I've had some cases where the petitioner, which would be the person seeking the guardianship over, pays for those separately. Okay. Any other ones?
Nope, that was it. Thank you.
Okay. So the new guardianship funds are just the completely opposite, except that now there are some funds for those persons who have developmental disabilities case management. So that's what they qualify for. Okay. So these funds can cover petition costs up for 100 eligible adults. Okay. So this is kind of like, there was a cap on this program when it passed. But each petitioner for the guardianship establishment funds for DD case management would get a maximum cost of $3,000 per person. So that $3,000, I shouldn't say per person, that for the ward to the attorney. So it would get paid directly to the attorney. And they would collect the $3,000 to do the guardianship. So basically do just everything that I spoke about, okay? So since this is new, you're gonna see these little websites up here, but I'm gonna kind of show you what it looks like. Okay, and these will be sent out to you as well. Okay, so the new one we're talking about, here's the protocol from the Department of Health and Human Services. So this will go through the protocol of all what this is. This will come out to you. So here's the referral source and here's the request for it for the guardianship establishment funds. I currently do not know how many people have accessed this. I know a couple on this call have helped with this, and I've helped with 4 personally accessing this program. Everything seemed to work pretty well, pretty quickly. I didn't really have any hiccups with my folks. I referred to this program, but some may. So you can take a look at this because this will come out to you. But I'm going to tell you what looks so interesting to me because the applications look almost exactly alike. So you really got to read them. So this one, okay. This one is for where we see here down, we're going to see these. It's in Word for some reason tonight, but you'll see down here where it says program eligibility. It says, is a consumer eligible for developmental disabilities case management? If yes, stop. So make sure we're all looking at the right ones because this is not the one for the folks with DD case management. But the one that is for them looks almost exactly alike. Where is it? Here it is. Please, is this the one that showed? Nope.
That's the one you just showed, I think.
I know. I don't know where that one is. that one disappeared on me. Okay, I don't know where it is now, so I don't want to people, but just make sure you're going to get both of them so you can see the difference. Just make sure that you're reading the difference is going to be where the stop is. The other one is going to say, and I know Roxanne has this application too for you folks in the room, but the other one, when you read it where the stop is, it's going to say, you know, do you as a consumer are able to access DD case management? It'll say, if you say no, it's going to say, if you say no, basically you're on the wrong application. But almost everything else is exactly alike, but those two will be sent out to you. Okay. I don't know why this freezes every time. But just a little bit about 5-year reviews. I can go to change. I hate technical prep. Yeah, basically you can start talking about, hopefully I can get this to go back and share, but the 5-year review, like I said, is required. You will get notice. Okay. I might have to just keep going. But for the 5-year review, you will get notice from the clerk of courts. And then it is a court hearing. You'll meet in front of the judge to see if you continue the current guardianship the way it is, continue with different guardians, or it can be also the possibility of termination if there's a contestant to it, or you choose not to be a guardian anymore. The district court usually mails out the notices 90 days ahead of time. Even though mine's coming up and less than 90 days, I haven't gotten a notice yet, but I think a lot of people lately I've been talking to are getting them about 90 days ahead of time. I do have questions sometimes when people say, well, I got my guardianship established in North Dakota, but I'm moving to another state. So when that happens, you have to follow the new state rules. So you want to get information on that. And then you're also going to want to talk to your clerk of courts about that. It's called the transferring of jurisdiction. And so you speak with your clerk of courts. You have a form that you sign, which would go to the clerk of courts in the new state that you are going to be moving to. And so their local rules, their state rules on guardianship may vary from what you're experiencing. A lot of times I see the biggest one is that 5-year review. A lot of states don't have something like that. Okay. And then just some miscellaneous things. If you're seeking guardianship or looking for guardianship, sometimes it's easier to establish that co-guardianship at the time if you know who that's going to be. In my case, it was my other son. It was a lot easier to go through that process just once to establish that co-guardianship. So you can appoint a successor to a guardian. Again, make sure that you're keeping the paperwork. You know, if you're selling off some of the ward's property, if property is coming into his place, make sure you're keeping track of that, because that's something you're going to have to report on the annual reports. And yeah, we recommend starting the guardianship process 4 to 6 months ahead of time. And now with the new law, you could probably even start earlier than that. Shopping around for attorneys is important because they can vary in price. And again, just making sure that you're looking at all your options. That would be the end of my PowerPoint if I could get it to move. Again, I'm not an attorney, so this is just a basic overview of what the process looks like through my own lived experience, and then from doing some trainings, different transition trainings and caregiver trainings, and then helping families across the state through this process. There we go. Sure, after I already talked. When you get your PowerPoint, you're gonna see this. This is the transfer of guardianship. That's the website if you're transferring. And that's the rest. And if you have just you know, other questions that come up later, you can send them to Deneen, or you can send them directly to me too as well. When you get the PowerPoint, my email will be in there, or my phone number.
I'll probably put that also in the main content of the email as well, Vicky.
Okay.
Does anybody have any questions at all? There was a lot of material, and Roxanne, it looks like you have one.
No, I was just gonna say thank you. We got off on a little tangent here. Thanks so much.
He is within walking distance to school.
Yeah.
But
Well,
I have
and
a question for you.
Roxanne is a great resource for this. So, I mean, I learned a lot of things from her. So she's sitting right there. So, you know, it's good to have, it's good to be able to talk to more than one person about this. So.
Kristen, you had a question?
Yeah, question. So with the supported decision making, does your child have to be able to say, yes, I want help with my, like you said, my finances, you know, my you know, medical? I mean, do they have to be able to cognitively be able to relay that, or not necessarily?
Well, I can't say that there's a rule, like there's no code that says that, because this isn't a court appointed one. But when you think about supported decision making on its own, it's the person making those decisions. So if a person couldn't finalize a decision like that, you're probably not looking at supported decision making. You might be looking only at partial guardianship. And another thing to think about, if you're thinking about this early on or whenever, if you're thinking about supported decision making, maybe that's some type of education your young person might be seeking out. I mean, that's another training that I do that we talk about, that is like, what are they learning in school about those things? You know, especially when you start that transition in IEP. You know, it doesn't have to be like, okay, this is what we always do for every child at this age, or this is what we do for every child with this disability at this age. You know, you want them to get education about finances and management and, you know, their health. I mean, healthcare goal transitions are big. They should be in there, you know, so maybe they could make those decisions, you know, so by that time, maybe supported decision might look like a more suitable choice. But if you really think that even education and even maybe role playing that role of what they might have to do is not going to work very well, you might want to think then more on a different, either partial guardianship, or maybe if it is just finances, look at power of attorney. I do have a lot that say I'm really worried about my young adult, my child signing an agreement of any kind, you know. So you kind of want to think about those things, but I also think for those folks whose kids are still in school, really look at your transition goals in an IEP, if that's what you're on. If you're on a 504, you know, those things could somewhat be even accommodated in there, especially when it comes to health. Maybe not so much of the academics, but, you know, healthcare, you know, learning how to make your own appointment, right? Because parents are doing that. And then all of a sudden your child might be off somewhere doing it and you're not sure that that's happening. So it's big on that. So, but if you had more questions or want to talk about it more, I mean, I'm always willing to talk to anybody and just kind of talk it through, or have more conversations with you about that, you know, to have a back and forth conversation.
I appreciate it. Thank you.
Yep.
Vicky, there's another question it's about identification cards for youth. Like, do you have an ID for Aaron?
Yes, I have a North Dakota ID. He had a school ID before that, and I have a North Dakota ID. That you just go to your motor vehicle department and you get, you know, it's basically an ID, but it's not to drive. It's not a driver's license. It's just a North Dakota ID.
That's probably a good idea.
The problem with those is, and I think they've changed that, you can't get a real ID. It's just a regular North Dakota ID, but I believe that got changed because otherwise, if my son was going to fly, he needed a passport when I got mine for him at 18. So you'll want to check that out. I've heard some people now can get the real ID, so that means they can actually get on a plane without a passport. When my son got issued his, you couldn't do that. You had to apply for a passport as well.
I'm pretty sure, Jake, I was trying to find his wallet. When he turned 16, I got a real ID. I just took him, if you go on the website, it just says what you need to bring for your documentations.
Yeah, I think it got changed right after we did ours because it didn't make sense at the time. And I don't think they actually thought about it when they did them. And so they're like, yeah, we have to have those. So,
and it really came
that
in.
real ID works for everything then.
And even when I had Jake volunteer at Courts Plus this summer, he had to do a background check. And then
yeah,
it was really slick for, that was one of his forms of ID. So
yep, absolutely.
We did get a ID for Alex, and it is a real ID. It does have the star on it.
There you go.
So
yeah,
because we need that for flying and for any travel on the ship, you have to have that.
Yeah, it's so much easier. Like I said, even when we got ours, I remember going up there and saying, well, this is kind of stupid. And they said, well, you could just use a passport. And I'm like, yeah, I get that. But so we have both. But yeah, I mean, when you think about logically, it doesn't really matter, right? They could still have the real ID. So
I have a question on, can you just recommend an attorney? I mean, I really don't know attorneys at all.
Right. So, I mean, I can't for sure, certainly on this call, but if you contact me directly, I can tell you some attorneys I've worked with or that families have told me they worked with, and those can be possibilities in your area.
Okay.
Okay.
But I can't, say that one is better than the other. Even if you look at attorneys, you, like I said, you do want to call and ask around. If you have absolutely no idea, thank you, Erin. If you have no idea, you'd be looking for like family law attorneys. They do a lot of guardianship. Okay. So,
okay.
But if you don't know any, you certainly want to ask around, to see what their prices is. The process itself is probably going to be the same for almost every attorney because it's a court process. The process looks the same. It's really just the fee and how they bill that fee. Some attorneys mine billed every 10 minutes. I had a good attorney who said, you know what, if you're going to ask me questions, do it all within that time. Don't call me this day and then call me another day to ask. He was very upfront with me. So I had a really good idea. He told me what the average cost would be. It can change in there. Guardian ad litems don't have a stationary cost. I mean, they all are somewhat in that range, but one could be higher than the other. So asking those questions is important. But
does the lawyer have to be in your county or can it be anybody in the state?
They have to just be able to practice law in North Dakota.
And the court that we would go to would be in our county, or is that anywhere?
Typically, but not always. My son, we live in Burleigh County and we had the court hearing in Morton County. It was the height of COVID, by the way. So I don't, but I've had others have to go to other counties.
Okay.
It's rare, but yeah, I don't know if anybody else on the call is heard of anything different, but yeah, we were in Morton County. That was one of the questions I had when they sent me the court hearing and the date. I'm like, oh, they got this wrong. And I called and they said, nope, we share those courts. So if you're in an area where shares the courts, it's possible.
Okay.
I think a lot's just going to depend on where you live. And you have to think about I live in Bismarck, so we're thinking Bismarck and Mandan, and they have the shared courts, so.
Well, that's the other thing for us. We live right on the border. So we're right between North Dakota and South Dakota. So our residence is North Dakota. But if we potentially look at a group home, we would most likely go into South Dakota.
Yeah, but your guardianship would still be established in North Dakota.
Okay.
If, you know, if you move to South Dakota, you would have to transfer the guardianship to South Dakota. They actually have different laws than we do. So
But
process is pretty similar.
If he lived in South Dakota, but we still lived in North Dakota, would we be okay?
Yes.
Yes, okay.
If you're the guardian.
Yes.
Okay, if you're the guardian. If the group home is the guardian, they would establish under theirs, okay? Like if you decide that the group home is going to take over the guardianship, typically they would only take over like possibly a rep payee position off of Social Security. But so that you have, if the ward and the petitioner move to another state, then you have to transfer, okay? So that if you were the guardian and for some reason you chose to move to South Dakota, then you would have to transfer. If he's just in that group home, he's okay. As long as they're not the guardians, okay? And the reason I say that is most of the time you wouldn't see that, but I don't know group homes in South Dakota very well. So maybe sometimes that happens, you know what I mean? Because every state has different rules.
Okay.
Any other questions at all before we go for the evening? Vicky, thanks a lot for this. Was great. I learned something new every time. So,
well, thank you. I mean, my biggest thing is here is anybody still that's left on. I mean, if you want to just have conversations back and forth, that's probably what I'm better at. And then if questions come up, I can give you the resources too, to try to look like even in the South Dakota one. I mean, if you're seeking out an attorney, even though that's the way the rule reads in North Dakota, you're going to want to talk to your attorney about that as well. Make sure you let them know that his residents might be in a group home in South Dakota.
Okay.
Another question came up, Vicky, and I know you're going to enjoy this question. It says, do students get training about this through the schools?
No, they do not. Typically, if your child is on an IEP, the case manager will say, have you thought about guardianship? That's about as far as they go, okay? That's a question that most districts say as case management, you have to ask in an IEP transition meeting, but sometimes they'll give Family Voices as a resource if you want to talk about guardianship, but that's the question they'll ask you. They'll also ask you, once you know, if you're getting close to that 18 age and you're still in school and you're doing that transition in IEP, they'll say, you know, have you applied for Social Security income? So supplemental security and SSI. But that's again, as far as they go, they say, have you applied? Is it something that I would like to see schools have a little bit more information on? Absolutely. Because your kids are at school most of the time. So it would be nice to have information on that.
All right. Any other questions at all before we go? Again, I'm going to be sending out the recording and all the materials and the handouts that went with tonight so that you have them as a resource if you want to share them with other families, or your providers, or whatever the case may be, if you want to start the discussion, whatever you're comfortable with. So I'll be sending that out in the next couple of days. So I'm grateful for everybody that joined tonight. And if one last thing, if there is a topic that that you are wondering about, or you would like to know more information about, and maybe an extended learning call like tonight would be helpful not only to you, but it might be helpful to some other families as well. So if there is a topic that is of interest that we haven't done yet, please let us know. We're happy to look for new topics for families as well. Our next call is going to be November 14th with Larissa Schwab from the Bismarck Public Schools, who's going to talk about adapting the regular curriculum for some of our kids with that need that help. So that announcement has gone out, so watch for that if you're interested in attending that one too. So again, thanks, Vicki, very much. This was awesome.
Thank you, everybody.
Good night, everyone.
Thank you.
Thank you.
Nice.